Again, welcome. Going to be talking about protecting preserving our legacy today. That's going to cover quite a few topics, really from estate planning to a surviving spouse and what they have to do, to what a probate looks like, to what a trust administration looks like, to things to consider when someone's passed away, from a trust administration standpoint to estate planning standpoint to an incapacity or disabled standpoint, right? There's quite a wide breadth of topics we're going to be discussing today. How to update title to assets, what to do with creditors, right? When someone has credit cards, whether that's secured, unsecured debt. Is it a joint credit? Is it a debt? Is a sole separate property debt? So on. So we're going to get into a lot of different topics, delve into a lot of different areas. So I'll kind of start beginning now, just so we can kind of get into the meat potatoes of the presentation. Okay. Just a picture of myself here. I'm an estate administration attorney here at Kopenbarger. I do trust administrations, probate, conservatorships, guardianships, as well as some estate planning and tax planning as well. Okay, a little bit of today's agenda. I kind of briefly already mentioned what we're going to be going after, right? The initial steps after a loss. A lot of times, especially if it's a surviving spouse, people think that, oh, I have a trust, so I don't have to do anything. Yeah, that would be incorrect. There's quite a lot that still has to be done. The auspice of having a trust helps one minimize those steps, minimize court involvement, minimize expenses and costs to the extent possible, but there are still things that have to be done. Moving next, trust administration and probate, right? What those mean, what is a trust administration? What is a probate administration? How do they differ? Why would one do one versus the other? When do you have to do both? And when can you avoid probate entirely? Next, the role of the trustee. What is a trustee's duty? Who do you pick for your trustee? You know, what's the thought process for choosing somebody? If you are a named successor trustee, what is your role? What are your duties? What are your responsibilities? What is your liability? And how can you mitigate and minimize any one of those? Financial obligations, right? What do you have to do once someone has passed away when it comes to their ongoing bills, whether that's utility, property taxes, mortgage, credit cards, outstanding medical expenses, and so on and so forth, okay? And document maintenance. What has to happen? Well, one, what does document maintenance mean? And then two, once we've kind of gone over what that means, what are the different strategies for that maintenance, right? And from a general overview, that's going to be update. Do you need to update your trust? Do you want to update your trust? Can you? Is it irrevocable? Do you even have the power to update it? Your powers of attorney. It's a good time to look at the powers of attorney. Who have you named? Are they still able to act? If they are able, are they geographically appropriate to serve? It may be that you have someone who's appropriate, but they're numerous states away. So they may not be able to serve you that much. Again, with technology and things evolving, that is becoming less of a concern, but we'll kind of delve into that. And then lastly, how can we help, right? What does Kopenbarger do to help you walk through all of these processes? How do we help you come up with a strategy that's appropriate for you and your family? This is going to be a lot of general information. Each person's particular circumstances are going to vary. So I just kind of want to set that out right there. As much general information as possible. There's going to be different family dynamics, different asset dynamics, different background. That's going to change each particular case. Okay, these are our attorneys here. You have probably at least seen a few of them, if not all by now. So we have people that are estate planning attorneys, estate administration, business and tax, estate litigation. We have a wide gambit of all of the different sub areas that kind of fall under the umbrella of estate planning. So when you hear the term estate planning, that does encompass administrations, both probate, both trust administration, both conservatorships, guardianships. It includes potentially state litigation as well. Those who are actually fighting over a particular probate or trust matter within the confines of a superior court. This is some of a bigger picture of our staff. So included in this picture would also be paralegals, legal assistants, accounting, you name it. We have numerous locations, okay? I am currently at our South Coast Metro. That's our main office here in sunny California, although it's overcast right now, unfortunately. I'm sure some of you know this. You can meet with our attorneys at numerous locations. If you're located somewhere else outside of Orange County, we're happy to meet with you in those other locations if it is more convenient for you. Okay, starting with the real topics that you came here to learn about and to discuss, right? The initial steps after a loss. And this, again, this pertains to anyone and everyone, whether you're a surviving spouse, whether you're a child that has lost an initial parent or potentially a second parent, whether you're a sibling or a parent of a child, it does not matter. There are things that have to be done no matter who is the one that has passed away. So just because you have a trust, that does not mean a lot of these steps happen automatically, right? A trust is just a vehicle for the way you administer one's estate, right? And we'll go into the difference between a probate estate and a trust administration, but that's just the vehicle. It's just the avenue, the mechanism for how you're going to be winding up and resolving a loved one's affairs. It does not mean that it automatically occurs. There are going to be things that you have to do, things that an attorney's office has to do, things you'll do with your CPA, potentially with your financial advisor. Sorry. There are things that you're going to have to be doing with the updating records for your real property, right? If you have a business, making sure your business entities documents are updated appropriately. There's so many considerations that still have to be discussed. Now, your particular case may not have to go as far, into depth on certain matters, right? And that's why you want to meet with an attorney, meet with your advisors, make sure you know what the appropriate steps for your particular instance and your loved one's affairs are. Okay. Some of the initial steps after a loss, right? Some of the legal considerations, notifying authorities. Who are authorities, right? That could be the taxing authorities, right? The California Franchise Tax Board and IRS. Or if you were living out of state, right? Whatever states, if you're in Nevada, the Nevada, whatever the equivalent for the California Franchise Tax Board would be, the Nevada Franchise Tax Board. And then additionally, the IRS for your federal taxes. You also, if someone's receiving Medi-Cal, right? You have to notify the California Department of Healthcare Services or some similar state-provided healthcare insurance program in another state, okay? There are other authorities. I won't get into that necessarily at this point, but notifying these authorities is an important step, okay? Sometimes, I'll retract that. A lot of times the funeral home will notify Social Security. And while clients come in and say, well, Social Security was notified, weren't all these other institutions notified as well? The answer is no. The Social Security office does not contact the state of California and notify them that a death certificate has been issued by, the funeral home or by the state agency and so on and so forth. Okay. So that's a common misconception. Yes, that's great that Social Security has been notified. But even to that end, Social Security does not notify other federal agencies either. So if there are other agencies such as the IRS, or any other ones that have to be notified, right? Those are some of the things that we have to discuss and go through, whether it's applicable to your loved one's estate or not. Obtaining death certificates. We have clients who come in and do not have the death certificate yet. Okay. Almost nothing can be done without the death certificate. So that is a huge step. So I have clients come in who are extremely on top of things, right? Someone passed away, and 2 weeks after that, they're in our office and they're trying to get the process started, right? So from my end, that's fantastic that you're coming in so early, but then they'll say, oh, I don't have the death certificate yet. And then I will say, well, look, we can't get a taxpayer identification number. We can't notify certain authorities. You're not going to be able to go to the bank institutions, financial institutions, right? They're all going to be asking for a copy of the death certificate. And we're going to need certain information from that death certificate to get a lot of the documents started. So just be aware that if you want to come in that early, absolutely, we can go through everything. We can talk about the estate, but nothing can really truly be done until that death certificate has been obtained. Next, the immediate legal actions. Okay, there are certain things that have to be done because there are statutory deadlines that need to be followed, right? One of those being you have to lodge the original will within 30 days. You have to file a change of ownership statement with the county assessor's office within 150 days. There are statutory notices that have to go out to beneficiaries and heirs that start a statute of limitations. If you're filing an estate tax return, right? If you have a larger estate and you have to pay inheritance tax, you have 9 months to file that without extension, right? There are your general normal when you have to file a final individual tax return, right? There are tax reporting deadlines. And there's a whole host of other deadlines that we have to discuss. They may not apply. right? As you'll see, a lot of these things may not apply to your particular instance, but we still have to discuss it and make sure. Okay, and that goes hand in hand with contacting key advisors, contacting your attorney, contacting your financial planner, contacting your CPA, and anyone else that is a professional and an advisor regarding your loved one's affairs. Now, again, without the death certificate, you can't do too much. So for example, if you have your spouse had an IRA, and that IRA or 401k named you, right? The surviving spouse as a beneficiary. You can contact them and you may have a relationship with the financial advisor, but they're going to ask you for a death certificate, right? To prove that this person has passed away. And a lot of times, if you don't have it yet, they won't be able to initiate a spousal rollover or even get the process started. So just contacting your advisors when it's appropriate, once you have the death certificate. Make sure you're scheduling meetings to have a discussion. Make sure you're doing everything you're supposed to be doing. And along with contacting your key advisors is securing the deceased property. And this is kind of a loaded statement, securing the deceased property. Well, what does that mean? Well, it means a few things, right? Marshaling the assets, finding out where they are, updating title to them, making sure everything is being done appropriately, making sure they're protected from heirs who may be entitled and are trying to get the assets earlier than they're entitled to, or maybe people who are not entitled that are trying to access these assets. And how to secure that will depend. Is there a trust? Is there no trust? Is there a will? Is there no will? Right? And you can kind of see, and we're going to kind of go through the different scenarios of how to secure a deceased property depending on what documents were done during the lifetime. Okay, initial steps after a loss, like some additional legal considerations, right? Reviewing the will and the trust documents. So when you meet with an attorney, they're going to review the will and the trust documents with you. What does it say, right? What the trust document itself are your guidelines, right? It's your legal document guidelines. It's your instructions. The trust is your instructions on how to administer the estate. Now, there's a lot of legalese and a lot of information you may not understand in there, and that's kind of the job of the attorney and the CPA to go through those terms and those sections for you to kind of give you an idea of what your job is going to look like, right? Along with that, informing financial institutions and insurance companies. Like I said, once you have the death certificate, you'll need to contact the IRA administrator. If there's a 401k, you need to contact your spouse's or your loved one's employer, right? And initiate that process. There may be a final paycheck that has not been issued yet. So you'll need to initiate that process. If there's life insurance, right, and there's a death benefit, you'll need to provide the death certificate to them and get that process started. Whether you're named as a beneficiary or the trust is named as a beneficiary or other individuals or charities are named, either way, it still needs to be contacted, right? So you're starting to see that a lot of these things are not occurring automatically, even though one has a trust. For example, I could have a trust and I could have all of my assets in that trust, but I could also have a life insurance policy. And I named a child from a prior marriage as the beneficiary of the life insurance, right? Even though that person is not a part of my trust potentially, I still need to notify the life insurance, right? I still need to let them know and let them get that process started. Handling the deceased mail and digital precedents, right? We need to be going through their mail because that's going to be a clear indication of what creditors are out there, what debts, what outstanding invoices, what bills are on automatic payment or not on automatic payment and need to be dealt with. And then kind of along with that digital presence, a lot of us get email statements for our checking, for our investment, for our credit cards, for our utilities, right? Having access to the digital online presence that your loved one has created during their lifetime is also becoming extremely important, right? Especially with the more ever present and ongoing digitalization of our financial wallet, right? I myself have a lot of my assets online, right? Even if it's with a bank that has a physical brick and mortar, Bank of America building I can walk in, my investments are all online, right? I actually don't really have paper statements. A lot of that is done digitally. So having access and knowing where to go and who to contact is paramount. Organizing important documents, right? Staying organized, making sure you have, a lot of times some individuals will keep documents for decades. Sometimes we have clients come in and they just have 40 years of documents and they go, wow, my spouse or my father or my child had so much information. Do I need to keep all of this, right? And the answer is most of the time, no. We need to figure out what are the important documents, what are the ones we need that are going to help guide us at this particular time. and then starting probate process if necessary. And I'll kind of go past that because I'm going to go into that in much greater detail as we kind of move through the presentation. Okay, emotional considerations. This is just as, if not more important than the legal considerations, right? When you go through a loss, right, you're going to be dealing with a lot of different emotions. You're going to be dealing with grief. You're going to be dealing with potentially dealing with a funeral, and a service, and communicating with other loved ones. And I mean, this can trickle out so much further, right? There may be loved ones you haven't seen or talked to in a long time. There may be loved ones who you do not have a good relationship, and now all of a sudden they are thrust back into your life, because you are the named as successor trustee or whatever the case may be. You're not having to deal with that. And one of the main goals of having an estate plan that is done, that is properly funded, and that is up to date is that it allows you to deal with the grief rather than focusing on scrambling because this person's affairs were not in order. So that's one of the things I talk to clients a lot about. It's just, and your own mental health is also paramount. Okay. Making sure that you are doing okay, making sure that you're actually grieving and mourning this person's loss and allowing those emotions to flow through is extremely important, because if you're not also allowing those things to happen because you're not able to, right, because you're so busy dealing with this person's affairs and trying to get things in order, that's going to affect you, right? That's going to affect you both physically, mentally, emotionally, and it may make it so that you're not able to do your job as successor trustee or power of attorney or whatever the case may be effectively. So that's very important that we're also discussing the emotional consideration, right? And then a balancing, kind of going along with that, balancing emotional and legal responsibilities, right? It's a balancing act, and no one has it figured out. I certainly do not have that figured out. And anyone who tells you that is just not being truthful with themselves. There are going to be times it's mountaintops and valleys, right? There are certain times when you're doing a great job at managing that, and there's going to be times when you're not doing a good job at managing that. The best thing to do, and it kind of goes along with these next steps on here, the next bullet points, is to be checking in with yourself, right? Check in with your advisors, check in with your family members, ask for help when it's needed, right? Making sure you're asking the attorney, I need guidance and assistance, making sure you're asking a loved one or a family member or a friend or a neighbor, whoever it is in your life that you trust and feel comfortable with, can you assist with me with this? Or at least, can you assist me with my emotional considerations, right? Can I talk to you? Seeking professional help, a psychologist, counseling, whatever it is that you choose is best for you, right? Just make sure you're not holding that in. You're talking about it, you're communicating, and you're expressing those feelings. Self-care and stress management is extremely important. You're not able to do your job if you're also not making sure that you're okay. Okay, you are your own star player here. And the better that you're taking care of yourself, right, the better you're going to be able to take care of this person's affairs. And like I said, seeking professional support from multiple people, right? That could be the CPA, the attorney, the financial advisor, your own loved ones, your own friends, whoever it is in your life that can assist you through this difficult time. Okay. Trust administration and probate, right? The processes, responsibilities, some of the pros, the cons, the differences. We'll kind of delve into what those look like at this time. Okay, overview, trust administration and probate, overview of trust administration process. There are, kind of when I meet with a client who's coming in, who has a surviving spouse, or whether they're adult child, right, and their loved one had a trust, I go through a comprehensive trust administration overview, a process with them, and I kind of go step by step. Hey, this is everything that's going to transpire, or mostly everything. There are going to be unknowns that pop up here and there, but this is going to be kind of the roadmap of what we're going to be doing during this process. Okay, and there are quite a bit of differences. I do the same thing when a client comes in and says, hey, my spouse did not have a trust. They did not have a will, and they have passed away. What do I do? Right. And now we're, a lot of times people are panicking, and it's like, okay, there's a probate process. Yes, we want to avoid probate to the extent that we possibly can, but in certain instances, we cannot avoid it. And I'll kind of, say that the probate is there to kind of guide you, right? It's still an administration. It's still a mechanism for administering one's estate, right? So it's still a way for us to be able to get control of one's estate, to manage the estate, to make sure that the appropriate creditors and debtors and so on are being paid off, and that the beneficiaries are being protected, the assets are being protected, and so on. So I'll kind of walk you through that process. And then really the key differences between the trust administration and a probate administration, both from a cost perspective, a time perspective, and then the privacy nature or not nature of those two types of administrations. And then additionally, as we go through that, some common challenges and solutions will just naturally kind of pop up through the course of the discussion. Okay, so this is the, we're going to talk about a little bit here, trust administration of probate again, roles of the probate court. The probate court is just there to protect the estate. Okay, I know that the probate has a negative connotation, and it should, right? There are increased costs, increased scrutiny, right? The court is overseeing all of your actions. Everything you file with the court is public, right? So if you're doing a probate estate and I am Joe Schmo, unrelated, but I am a creditor, I can search your name. If I found out what county you passed away in and I search the court case docket and I pay a couple of dollars to do that, I can find that you filed a probate administration, right? And I can pay for copies of those documents. So now I know a petition's been filed. I know when an inventory has been filed detailing the estate's assets. I know when a final petition has been filed asking the court to disperse the funds to the beneficiaries, right? I have all this information, which if I'm a creditor, it's fantastic, right? Because then I know who I can go after, who has assets, and so on. So right, those are just some downsides. But some upside is if someone doesn't have a document or doesn't have a trust, right? This is a way to protect their estate, right? It's a way to make sure that the appropriate parties are receiving your loved one's assets, right? It actually has, the state of California, if you do not have a estate plan, the state of California sets one for you, okay? Now that could be good and it could be bad, right? Because if you're a surviving spouse, and it was like everything you owned was community property, right? Generally speaking, that community property goes to the surviving spouse, but they have to file an action with the court to do that, right? Conversely, if another relative came out of the woodwork and said, hey, I'm entitled to these assets, they would have to go file the petition. Otherwise, they would go to a bank and say, hey, these assets are mine. The bank is going to say, where are your order and letters, right? Where are your probate court documents showing that, one, you've been appointed as the administrator of the estate, and two, where's your order saying these assets have been distributed to you, right? So that's kind of a protective measure to make sure that these individuals who are not entitled do not and are not able to access these assets, okay? Type of assets involved. So for a probate, the assets that are involved are a few items, right? Even if you have a trust, if you do not fund your assets into the trust, they are probate assets, okay? So anything that you pass away with in your name, or that your lover has, your loved one has passed away with in their name, can be subject to probate. So if I have a checking account at Bank of America, let's say, and it's in my name alone, and it has $200,000 in it, okay, and I pass away, that is a probate asset. To avoid, and I'm going to kind of touch on avoiding probate. To avoid that probate, right, I could have created a trust and then put that Bank of America account into my trust. Now, when I pass away, that is a trust asset. It goes via the terms of the trust, and the successor trustee has access to go to the bank, marshal the assets, and do what they need to do to pay my bills, wind up my affairs, and so on and so forth. Okay. Some other assets that could be subject to probate that people generally think are not: life insurance policies and retirement plans. Well, people go, wait a second. I thought you can name a beneficiary on my life insurance policy. Sure, you can. What if you name your spouse and your spouse predeceases you, and then you don't name a backup, right? Now, when you pass away, there's no one named on this life insurance policy. That life insurance policy becomes of your probate estate. Same thing happens for retirement plans. If you name your spouse and then your sole adult child, and both of them predecease you, again, God, forbidden that would happen, right? But it does. These instances do come up. And now all of a sudden you have a $3 million 401k or IRA that is now subject to probate. And I'm going to go into what the probate costs and fees look like, and I'll use a dollar amount so you can kind of see how expensive it is, right? And that's really one of the downsides, is the length that a probate takes and the costs and attorney's fees that are associated with it. But yeah, those are some of some of the off instances, and people will go, well, I created my trust. I'll use a surviving spouse example, right? Surviving spouse comes in and says, well, all these life insurance policies and my retirement accounts all have beneficiaries. And at that time, I will always say, no, look, as a part of this meeting, as a part of your job, you're going to be contacted. You're going to contact and reach out to all the life insurance, all the retirement plans, any annuities, any and all of these financial institutions, and you're going to confirm, right? You're going to look at the beneficiaries. And you're going to make sure they're up to date, and we're going to have a discussion on whether you want to name the trust as a beneficiary. Okay. Same things happens where I see this a lot with joint assets. A bank, I have clients who will do an estate plan for, will do a trust. They will go into the bank and the teller, some 22-year-old, will say, no, no, no. My manager said, don't put this in the trust. Have it as a joint account. It's much easier and you'll be fine. And the clients listen. And then they put their assets in a joint account. And then when the first spouse passes away, they walk in and they go, look, here's death certificate. They take the spouse off and it goes to them. And technically, yes, that was okay advice for that first time, right? But then they don't do anything. They just keep that asset in their name. And then the surviving spouse passes away. And that account had $400,000 in it. And now we're having to do a probate because of the structure of that, rather than putting in the trust back when both of those individuals were living, back when they had capacity, and both when they had recently done the estate plan and were recently advised on how to update title to everything, right? And now we have an instance where the loved ones, even though there's a trust, they're having to file a probate. Okay. And that's what we want to avoid completely, because are you going to have your loved ones? One, you paid money, right? You paid a lot of money to do your estate plan. And then there is still costs associated with the trust administration. So your loved ones are going to be using, hopefully, your assets to pay for the trust administration, but now they're having to simultaneously pay for a probate on top of that. So now you can imagine and extrapolate how expensive this can get. And all of these fees, where are they going? To the attorney, right? Do you want all of these fees to be going to us? No. Do we want them to be going to us? No, we don't. We're not here to gouge people money wise, right? We want to make sure it's done appropriately, but we also need you to be, following along with the funding instructions when you create the trust, right? So there's a lot of things we can do to avoid the probate. I know I'm kind of hammering this on, but it's really important part of this webinar, especially for, a surviving spouse, or a loved one, right? It's when you come in, you should be checking your documents, and I'm going to touch on this a little bit later as well. Looking at and reviewing not only your estate planning documents every 3 to 4 years, but looking at your financial outlook, right? The entire big picture of your finances. Okay, how are assets titled? Are the beneficiaries on there appropriately? If we have joint accounts, are they done appropriately? How can we avoid probate? Do our documents appropriately and accurately reflect our desires? Okay, so you're gonna have to be doing this every few years and whenever there's a major life event. That's just something that I always tell any clients that I meet with. Okay, and then kind of along with what I've covered, understanding the costs involved, and then dealing with disputes and claims. So disputes could be inter-family, intra-family, it could be creditors, it could be those who had judgments against your loved one while they were living, right? They got in a car accident and then they were sued, and someone got a judgment against them, right? What happens when that person passes away? Does that judgment go away? Does it remain? Who's responsible? Who's liable? What that looks like, and how that differs under a trust administration versus a probate administration. Okay, probate costs. Right, so we just kind of talked about the threshold in California for when someone passes away, when you have to file a probate, at least as of 2024, is 184,500. Okay, so if I pass away and I have a Bank of America account that's in my name alone, right, not in my trust, with no beneficiary on it, and it has 200,000, right, and I pass away, my loved ones, right, my spouse is going to have to file a probate for that asset. Okay, and we want to give you kind of an idea of what these fees and costs look like. So you see this total approximate cost of 50,500, and you're going, whoa, how did we get to that? Look how, and this is the example, right? Median home value in California is now close to $1 million. Okay, so if this person at a minimum just owns a home in California, right? That home is going to be valued at about $1 million. And the probate court does not take into consideration, for the purposes of filing a probate, debt. So even if you had a $900,000 reverse mortgage, which would knock down the actual true value to 100,000, that doesn't matter. Your loved ones still have to file a probate. Okay. And our fees are still based on that gross amount. Okay. Unless the asset's been sold, right? Then there are deductions, but I don't want to go into that at this time. Yeah. So looking at this, just if they had a median home, right? And let's say there's no debt on that home, right? There's a statutory schedule that the state of California sets forth to dictate attorney's fees. It is not hourly, it is not flat fee, it is not contingent. Okay. There is a schedule and it is based on the size of the estate. So for example, it says 4% of the first 100,000, right? 3% of the next 100,000, 2% of the next 800,000. Okay. So if we look at that 4%, 3%, 2%, based on a $1 million home, that results in $23,000 in attorney's fees, right? That's quite a lot. Okay. And on top of that, the administrator or executor, whoever is managing the probate estate, is entitled to the same fee. So if you name a sibling as your executor, or let's say you don't have a plan, you don't have a surviving spouse or children, and a sibling is the one who becomes the administrator, right? They're entitled to the same exact fee that the attorneys are. So right there alone, just in fees, we're talking about $46,000, right? That's a lot of money that can be avoided. Okay. Along with that, there are court costs that are automatic. Does not matter what your estate looks like. Doesn't matter if you have 10 million going through probate or 500,000 going through probate. These costs will always come up. Okay. The court is going to appoint a probate referee to appraise the assets as of the date of death. Okay. That has a cost. There is an initial filing fee whenever you file a petition for probate. It's about $600. You have to publish your petition in a local certified newspaper. There is a publication fee ranging from $400 to $2,000. And then there are miscellaneous costs, right? There are e-filing costs with the court. There are numerous document filing costs outside of the petition. There's the inventory filing. There are creditor claims you have to deal with that may also cost filing costs. There is a final petition that has another $600 fee attached to it. There's a final order that has a $60 fee attached to it. There's an ex parte discharge document at the end that has costs associated with it. So you could easily see here how it could actually exceed $50,000, 500 on a $1 million estate, right? And what happens when you pass away with a $2 million estate, right? Double these costs, right? It's no longer 50,000, not the cost, but the fees, right? So we're looking at $80,000 maybe total on a probate estate that could have been done for a fraction of the price if a trust was created and, more importantly, properly funded and continuously, ongoingly checked for accuracy. Okay. The processes and timelines for a probate. Okay. When you have a probate, you have to go through not only the California state rules, but the county rules. And on top of that, the particular courtroom rules. There are numerous rules that we have to abide by. And a lot of times this causes delays, right? Because if we are complying with the state of California, we're doing everything from a California state law perspective correctly, that doesn't mean we're not going to trip up or do something procedurally incorrect based on that county or based on that particular judge and courtroom that may require something different. Okay, so if we filed the initial petition for probate, we've provided all of the information that California says we have to, right? As attorneys, we've done our job. And then a couple of weeks before the hearing, we get some probate notes saying that, X, Y, and Z were not taken care of. And we're going, well, those are not requirements under state of California. They are what are called local rules, and we cannot get around them. We have to abide by them. But maybe the court didn't give us enough time to abide by them before that hearing. And now that hearing gets continued another 3 to 4 months. So your loved one has passed away in July of 2024. And because of a court procedural requirement that local court requires, your initial hearing, which was 2 months out, gets continued another 3 months. So now your loved one passed away in July. It's now December. No one's been appointed. And because no one's been appointed, no one has authority, right? You have no authority to access the assets that are in their name. The banks are not going to allow you. The financial institutions are not going to allow you, right? You're going to hit a lot of roadblocks, and that's going to create even more stress, more anxiety, because what if you yourself do not have the means or the assets to be paying bills? What if there's a mortgage? What if there's a reverse mortgage? Lenders are notorious for trying to call the loan immediately. Right now, there are extensions and you can communicate with them, right? But they are very aggressive. right? And if you're having difficulties getting appointed, you don't have access to these funds to be making these payments. So either you're coming out of your own pocket, either you're going in a personal loan, or you're putting another mortgage on the property, right? Depending on if you have other assets or not, to deal with this. And again, all of this just competes, right? Your emotional responsibilities are now competing with your legal ones. And this is creating quite a bit of a headache and heartache on you that can be avoided. Another problem with probate is the timeline. Okay, we have a minimum of 18 to 24 months. That's on average. Have I done a probate before in under a year? Yes. Have I, there have been very rare instances where I've been able to do it in 9, 10, 11 months. That was fantastic. Is that rare? Absolutely. More often than not, it would take anywhere between 12 to 18 months. Have I seen it go as far as 24 months? Yes, on numerous occasions. Have I seen it go 3, 4 years? Absolutely. Have I seen it go 5, 6, 7 years? Absolutely. Okay. And the court can continue matters on their own, right? You and our firm and the CPA and everyone can be doing everything exactly how they're supposed to be doing it. And the court can say, you know what? We have a backup. We're reallocating these matters to different departments. And because we're doing that, not only are we switching the department, but we're continuing this hearing another 6 months, right? And they can continue to do that, right? So it's kind of out of our hands. And that's one of the downsides to being subject to a court supervised administration. And that's what a probate is, right? A court supervised administration. It is quite a bit of court over, you're kind of at the whim of the court system rather than doing things on your own time. Okay. Along controls with the court, not with the family. We have to follow the rules of the court. It does not matter what you want or what we want. We have to follow the rules of the court. If you are not granted full powers and you're trying to sell real property, we're going to have to petition the court to do that. We may have to do a public auction, right? And you're going, I don't want to do any of this. And we're saying we don't either, but we have no choice, right? The control is with the court. There are certain things that have to be approved by the court, certain actions that do not have to be approved if it was done via a properly drafted and funded trust. Okay, so there's a lot of different issues with that. Along with that is the privacy. A trust is private. Unless you file a trust with the court, in some instances you do, it is a private document, meaning the administration is done privately. Yes, we have to give notice of the death to certain institutions, but very rarely do we have to provide a full copy of the trust. Okay, with a probate, it is public record. And even if you try to file something under confidential seal in most probates, that's not going to happen, right? There has to be a overwhelming need, excuse me, an overwhelming need for the heirs of the estate to file something under like protective order or seal. Otherwise, more often than not, actually, I'm going to say 99% of the time, the court's going to deny that request. Okay. And again, the fees, conservatorship, that is when someone is no longer able to manage their affairs, but they don't have a power of attorney, advance local directive. I've actually recently did a full webinar on conservatorships and private incapacity administrations. I would suggest you go check that out. It's on our Copenbarger YouTube channel, and that's a great discussion of that. So I'm not going to go into a full explanation of that because I could do 2 hours on that myself, right? But the main part here is the probate fees. Talked about that. They're set by statute. They're not hourly. They're not lump sum. They're not flat fee. They're not contingent. They're set by the size of the estate. So if you have a $5 million estate and you do not do a trust, or you did a trust, but you did not properly fund it, we have to go probate that $5 million, right? Alone. That alone would result in, $60,000, $70,000 in attorney's fees. Okay. And we do not want to be dealing with that type of attorney's fees. What if it's just one real property? What if the house was worth $5 million, right? And that's all we're dealing with. And ultimately, the surviving spouse or the adult kids, whoever the heirs are, just sell the property to get the cash, right? All of a sudden, we ended up with 60, 70,000 attorney's fees. You paid an additional $4,000 in court cost fees. You paid another, $100,000 in realtor and closing cost fees for the sale of the property. You can see how $200,000 just left the estate for no reason, right? That was not necessary. Had that house been done in a trust, that would all have been avoided. Okay. So just be aware that probate has quite a lot of fees. And the worst case scenario is when someone somewhat properly funds their trust and we're helping a client with a trust administration, but then leaves assets outside of it. And now we're having to do probate on top of the trust. So now your heirs and loved ones are having to pay for both types of administrations, which could have been avoided. And again, I'm going to touch on this. Always be checking your documents every 3 to 4 years, any major life events. A common theme I've seen is I've created my trust in 2006, right? And I haven't looked at it since then. Yes, I funded and I properly funded everything back in 2006, but it's been 20 years. Have you opened and closed accounts, right? Did you start a job somewhere else and transfer your IRA or 401k or whatever it is, right? Did you have kids? Did you have grandkids? All of these things kind of pop up and you realize, oh, you opened up a 529 plan, but and you opened up an investment account or you closed these accounts, but you didn't retitle them appropriately. You didn't put them in the trust, right? So you did all this work in 2006 that was done appropriately. And then as life happened, which life happens to all of us, right? Regardless of whether we like that or not, it's going to, and things are going to happen. Things are going to change. So making sure that your financial plan is done appropriately, that these assets are titled appropriately can save your loved ones so much in not just time and expense, but in emotional grief. Okay. So this is the trust process, right? A little bit different. You see 12 to 24 months. Have I done a trust administration before in less than 6? Yes. Right. But on average, I would say 9 to 12, 9 to 15 months. Right. So it's a little bit, the timeline's a little bit shorter. That is really more up to the client, right? If the client and the attorney and the CPA and the advisor are all doing things appropriately, we can minimize that timeline. Now, there's other things that may come into play that lengthen it, right? If you have your loved one has a larger estate, you have to file what's called a federal estate tax return to pay inheritance, right? Estate taxes, also known as a death tax, right? That may elongate it. There may be issues where you're challenging a prior return and requesting a refund on behalf of your loved one, right? So things can kind of get extended. But generally speaking, it's a shorter process. Controls with the family, right? We don't have to file the trust with the court, and the successor trustee has a document that sets forth all of his or her powers, right? All the powers that the trustee has, all the things that they can or cannot do is set forth in that trust. Okay. And that trustee has the ability to make decisions based on the trust document and those powers. Okay. So the control is within the family. It's within the people that your loved one has designated to have that decision-making power, right? We're not having to go to court to seek approval before making these decisions. Okay. And then fees, right? Fees. I want to make this clear. Does a trust administration have fees? Yes, absolutely. Does it have the same as probate? In most instances, no. In most instances, probate fees will dwarf a trust administration fees. So if you have a loved one who's created a trust, right, has done an estate plan and spent thousands of dollars to do that, we have to make sure that they're funding and doing things appropriately to make sure that trust stays up to date. Because otherwise, they just spend all that money for you, the surviving spouse, or the surviving children, or the beneficiaries, right, whoever it is, and then has to go open up a probate and pay $20,000 when they, in reality, could have paid 5 to 10,000, right? And they could have avoided the necessary of filing these things with the court. When you file documents with the court, sometimes you have to give notice to people that you don't want to give notice to, right? In your trust, you can be very specific about who gets a notice and a copy of the trust when one passes away. Okay. When you file a probate, sometimes you have to provide notice to family members who are not involved or who you do not want to see your estate plan. You do not want to see your financial assets. Okay. So there's a lot of different competing interests here, a lot of things that one has to consider. And again, this is all something that your surviving spouse or your loved ones are having to deal with if a trust is not done appropriately. Okay. Or if it's not funded appropriately, or if your loved one did not create one. Okay. I'm going to kind of breeze through the role of the trustee process. I don't want to I've done a couple of prior webinars that discuss the role of the trustee that dive into that a little bit more, but I'll just kind of briefly touch on it. Who is the trustee? What are their roles? Who is the beneficiaries? Will they be involved? Okay. So when you're creating the trust, make sure you're having discussion with your family, with your spouse, with your, whoever's going to be involved, whoever you trust, your CPA, your advisors. Who do you want to name as your successor trustee? If you and your spouse are unable, whether you're unable because of incapacity, you're unable because you're just unwilling and don't want to be the manager of your estate, or because you're incapacitated or deceased, who is going to be the one managing your trust assets, right? And what are their roles? What powers do they have? Are they going to also be your agent on an advanced healthcare directive? Or are you going to name different people because you trust different people to make your medical and healthcare decisions? Okay. Along with that, who are your beneficiaries, right? Are they going to be your kids? Are they going to be equal beneficiaries? Are you going to have different distributions? If you have a special needs child, how does that distribution look? If you have an adult child who is receiving state or federal benefits, how do we make sure to protect that? If you're trying to qualify for Medi-Cal, how do we protect that? If you're already receiving Medicare, Medicaid, right? You can see how a lot of these different instances and different circumstances play out, and these conversations should be have. And then will they be involved? Well, essentially, will the beneficiaries be involved? It's very common to name, let's say you name your oldest adult child as your successor trustee, and they are also one of your three children and therefore one of your three beneficiaries. Okay. So you can kind of have, or do you want to name two of those three kids to be your co-trustees or all three, right? And the attorney can advise you through the pros and cons of naming a child, the pros and cons of naming joint or multiple co-trustees. I can just tell you from my own personal standpoint, I do not like co-trustees. James, a senior partner here, you may have seen him do some of these seminars, the live seminars, and he talks about there being multiple drivers in the same vehicle, right? If you have four co-trustees, that's like having four drivers in the vehicle, all with the steering wheel, all with the gas pedal, and all with the brake pad. And you can imagine how that would work if you're trying to get somewhere. So I'll kind of leave it at that. Again, we have some other literature and we have some other webinars that gets into this topic a little bit further. The role of a successor trustee, we kind of talked about that. I'm going to skip the top part here. We kind of talked about what EA is administration, both judicial, non-judicial, right? Non-judicial would be like a trust administration. Judicial would be like a probate administration, right? Judicial being within the confines of the court, non-judicial being outside of the court, okay? A successor trustee is someone who's responsible for making sure trust assets are distributed according to the settler's wishes, the settler being the creator, right? If I create a trust, more often than not, I am also the settler of that trust, right? I'm putting my intentions in that trust. My successor trustee is the person named that when I'm unable or unwilling to serve as trustee, this is the next person in line who's going to make sure that the estate, the heirs, the beneficiaries, the financial institutions, everyone is following the confines of my trust. Okay. The role of trustee. So this is a great slide because it's not just the role of a trustee. This is great for surviving spouses and for loved ones who are named as successor trustees. Okay, a lot of times people think that nothing has to be done because a trust exists. Clearly, just this is a snippet of the things that have to be done, and I could probably put 4 or 5 bullet points under each one of these bullet points. Okay, but just generally speaking, we've kind of, I've kind of mentioned it earlier on. We have to update the land records, right? We have to make sure that title is appropriately reflecting to reflect the death or the incapacity of a current trustee. Okay, so if you're a surviving spouse and you had a joint trust and both of you were trustees, you have to remove that spouse from title. Why? Well, if you're wanting to refi the house, how can you refi your home if someone on title has to sign that new deed of trust and they are deceased? Okay. If you want to sell the property, how can you sign a purchase or sale agreement if that person is deceased or if that person is incapacitated, right? And no longer has the ability to sign that sale agreement. Technically speaking, if you moved into a assisted living or some other facility, but kept your home and wanted to convert it into investment property, right? Technically, who signs that lease, right? You would need the owners of the property being both of you, okay? So there are numerous instances where we want to update the land records, okay? And this would be for your residence, your investment properties, you name it. If there's land attached to it, we need to update the land records. We have to notify the county assessor, right? Anytime there's a change in ownership, the county assessor wants to reassess the property for property tax purposes. Okay, but we need to file this notice with the assessor, and we need to indicate any exemptions, any exclusions, right? If you're a surviving spouse, we need to tell the assessor that the surviving spouse is the one who's receiving the deceased spouse's interest. So please do not reassess the property because there's a spousal exclusion. Okay, we have to notify the beneficiaries, right? If you name beneficiaries, whenever a revocable trust becomes irrevocable because someone has passed away, we have to notify the beneficiaries. Right, we have to let them know that this has occurred and provide a copy of the trust. Right, this is part of California law, and a lot of times, just as a shock to people, they go, "Wait, I don't want my trust to be provided to anyone. I don't want them." It's part of the law. We are required to do that. We have to give them a notice. It has to have very specific language, it has to have statutory language, and they have to have copies of the trust documents. Okay. Otherwise, certain statute of limitations do not begin. Right, and your role as trustee, your liability is extended indefinitely, right? So your liability could live on for decades if you do not do things appropriately. Notify the California Department of Health Care Services if one was receiving Medi-Cal or if there's a probate estate. Even if you're not receiving Medi-Cal, we still notify them and ask for a letter saying that the state of California does not have a claim against the estate, right? We want written evidence that they don't have a claim. Lodging the last will and testament. This is an outdated law, but it is still current law. Even if you have a trust, we have to lodge the original will with the county court. They put it in their vault indefinitely, and they give us a safekeeping receipt. A lot of times we have to obtain a taxpayer identification number. So for example, if I'm unmarried and I have a trust, right, and I pass away, because I passed away, my trust became irrevocable, right? My heirs can no longer use my social security number. So from my date of death and onward, they have to get a taxpayer identification number for the trust itself. You can think of that as a social security number for the trust, right? And that's what you're going to be using to open up new accounts, to access the assets, to marshal the assets, to report any income from the date of death until final distribution, and so on, right? But we'll want you to talk to your attorneys. We'll want you to talk to your CPA about what that looks like and why you'll need that number, okay? And then notifying federal and state taxing authorities, right? We have to notify the IRS. We have to notify the California Franchise Tax Board that you, as the fiduciary for this, for your loved one's estate, are going to be the one who is filing these tax returns, right? So we're giving them notice that you're going to be the ones potentially signing those tax returns and that you're the one to send any correspondence and communication to regarding any outstanding or ongoing or past due tax liability or tax returns, okay? Trustee duties. You can see that there are numerous trustee duties. The role of the trustee is not an enviable one, right? I have family members who fight over who want to be trustee, right? Because they think that they get all the power and all the control. And while that is true, they also have all of the responsibility and all of the liability. Okay, so I'm not going to, I'll just kind of briefly let you look at this. You can see duty to administer, duty of loyalty, duty of impartiality, duty to avoid conflicts of interest, right? Duty to not commingle, ask your personal assets, right? Duty to diversify. There are so many things that you have to abide by that you need to talk with your attorney to make sure you're administering the estate appropriately, and then you're not doing anything that would be considered a breach of trust, right? We don't want you to do anything that would expose you for liability, whether it's the heirs or beneficiaries you're exposing yourself to, whether you're exposing yourself to liability to another co-trustee or to other government agencies, right, or to the court itself, and so on, okay? The role of the trustee tax concerns, right? There's numerous taxes that we have to consider. Even if you're a surviving spouse, you need to come in and talk to us because there are deadlines on this, right? There's your loved ones' final personal income tax returns, right? You still have to file those. There are fiduciary income tax returns, and what that means is a trust income tax return, potentially, depending on the design of your trust and your estate. Estate tax returns, so that's not probate estate, but that's federal estate tax returns. That is what we talk, what in more general language is your inheritance tax, right? Your death tax. Okay, California does not have one, right? But the federal government does. Other states do, right? So you need to be talking with your attorney and your CPA to make sure that one, you don't have to pay any of this tax, and two, that you don't have to file this tax return. Okay, and there are specific deadlines for making these decisions and having to file these returns, or you may incur penalties and interest, okay, on top of any tax that you may owe. Estate tax portability, one of the very few benefits the IRS has provided surviving spouses. But again, there are deadlines, and we need to have the discussion on whether or not it's appropriate for you to be filing this return to port your deceased loved one's unused exemption into your own estate, and kind of the ever-changing laws with inheritance tax. I'll kind of table that because the focus of this webinar isn't necessarily estate tax, so because that's going to be too in-depth of a conversation. Income tax basis, right? Stepping up a loved one's tax basis, right? Depending on how the trust is designed, depending on the type of assets, we need to have a discussion about your income tax basis in real property, right? In securities and investment accounts, because if you're a surviving spouse, you get a stepped up basis. And sometimes if you are surviving children or heirs or beneficiaries, you may get a second step up in basis upon the surviving spouse's death. Okay, but we need to have that conversation because there are instances where there's only one step up, or where there's a partial step up, or where there's depreciation involved, or where there's adjusted basis conversations and variables that need to be discussed. Okay, but that's all part of what the trustee has to be responsible for, right? Dealing with all these different taxes. Now, like I said at the very beginning, your particular case, your loved one's particular case, may not have to cover all 6 of these, right? Maybe we only talk about 3 of these because that's what's ongoing based on the assets in your loved one's estate, but we still have to have the discussion. Okay, and last but not least, property taxes. A lot of you are probably aware or at least have heard of Prop 19 and how that changed a lot of the property tax benefits when one receives or inherits real property. Okay. However, if you're a surviving spouse, we still need to come in and talk about this because there's certain exclusions, there's certain exemptions for a surviving spouse, right? So the property taxes should not be reassessed for a surviving spouse. But if you're a child, they most likely will. But there are some instances when it's not. If you're not a child, sometimes there's a limited exclusion for a grandchild. But if you're a distant relative or a non-grandchild relative, right, you're almost automatically going to be reassessed. What does that look like? What was your loved one's property tax base? What were they paying on an annual basis? What is the current fair market value? What do we anticipate the assessor is going to reassess it? And what is that anticipated new tax liability going to look like, right? If you went from $1,000 a year property tax payment to a $16,000 a year property tax payment, and you plan on keeping that to the property to use as an investment property, you may not want to anymore, right? Because you're going to either have to raise rent so much or it's going to eat into your profits. It just may not be worth the hassle for having to manage an investment property, okay? So these are all discussions that we're going to be having. These are all things that the trustee and your loved ones have to consider. And the more that you do in your trust, right? The more discussions you have with your CPA, your advisors, your attorneys to account for and provide for all of these types of taxes, right? The more instructions you provide to your loved ones, the easier it is for them to navigate this process. Okay, I have instances where loved ones have no idea what their heirs or family members come in and say, I have no idea if my mom filed tax returns for the past 20 years. I have no idea where her assets are. I have no idea what the value of these assets are. I have no idea what her income tax basis is. It is in any of these. Okay, so that becomes quite a strain for this individual having to dig through, potentially rooms of paperwork or storage units of paperwork, or there is no paperwork. And now we're having to claw back and contact the California Franchise Tax Board, the IRS, and request tax returns, right? And now you can see how our attorney's fees are now starting to trickle up, right? We're on the phone with these entities for hours at a time and maybe unsuccessfully, right? Maybe we're not even able to get this information. So now we're having to use alternative and different avenues for trying to get this information, all of which is causing your loved one, whether it's a surviving spouse or a child or other relative or friend, having to deal with this, right? More grief, more emotional toll, while they should be really taking the time to grieve your loss. Okay, so these are all things that we can do to not completely negate, but to at least mitigate and reduce the stress when the loved one has to come in and do these different tasks. Okay, another thing that the trustee, that a spouse has to do, and this is particularly true with the surviving spouse, you still have to do things with title, and you still have to transfer assets, right? We need to have a discussion. Okay, did your wife or husband have any assets in their name alone? If yes, do we need to file a probate? Okay. Are there jointly owned? Is there jointly owned property? Yes. Okay. You need to update title to that. Do we need to then update title further to put it in your trust? Or is there a beneficiary we can put on it? Okay. Beneficiary designated property. If your spouse had a life insurance, or I'll use an IRA, your spouse had an IRA. Okay. You need to still initiate. It doesn't automatically roll over into your name, right? One, you need to confirm that you are the named beneficiary. Okay. You should be, but you still need to confirm. Two, we need to make sure that you roll it over into your name and make sure then, third, you need to name beneficiaries, right? It's now your IRA. You need to name beneficiaries on there. Okay. Same thing for any other accounts. If it's your own, let's say you had your own IRA, right? And my spouse passed away. She does not have an IRA, but I do. But my IRA names my spouse. And then I did not name contingent beneficiaries. Okay. So what happens now that my spouse was, if I don't do anything and I pass away, we have an issue, right? Because my heirs, my loved ones are now going to have to be dealing with the IRA or 401k plan administrator who won't speak with them, right? They're going to say, we won't talk to you. You need to give us a trust, or you need to give us the probate court documents, right? And now you're having to scramble to get them more information. Now we can't mitigate what they're going to request from you. We can't mitigate the difficulties that will no regardless come up, regardless if you have a trust or no trust, or you've done things appropriately. Sometimes these institutions are hard to deal with. So that's just something also that you can kind of tell your loved ones, hey, even though I've done everything appropriately, the attorneys have said sometimes you're going to get some pushback from the institutions. Sometimes you're going to talk to an account manager who's not familiar, or someone who is having a bad day, right? So these things do come up. But the fortunate thing is that's out of your hands, that's out of your loved one's hands, that's out of our hands. Okay. And then with probate, via last will and testament or intestacy. So if you have a will, you have no trust, you have a will, that will still has to be probated. Okay. You still have to go through a full probate process, just like as if you did not have a will. The only difference is that one, you get to name who the administrator of who the personal representative of your estate is, right? You get to pick and choose in your will. And then two, you get to name who the beneficiaries are, right? So if my will says I'm leaving everything to UC Irvine, right? As opposed to my kids, I could do that, right? And my executor would have to, and the court would have to recognize that, provided it was done appropriately and everything was legally satisfied. They have to recognize that, okay? Versus intestacy. What intestacy means is no probate, no trust, right? In that case, the state of California sets forth one, who has the priority rights to serve as my personal representative, and then two, who has priority rights to receive my inheritance, right? Whether that's my spouse, whether that's my kids, whether it could be my parents or siblings, and so on. Okay. And then next we have with trust, joint lifetime, after lifetime of first spouse, or after trust matures and is ready for distribution. So even if it's a joint trust that you've created with your spouse, okay, there are certain things that still have to happen. Updating trust assets, okay? If you had a joint investment account, it was properly funded into the trust, but it had both of you on as trustees, right? You'll want to remove that person, your spouse, from title, so it's just you on that account as trustee, and only you are necessary to make decisions regarding purchasing and selling, and talking to your advisor, and so on and so forth. Further, excuse me, let me take a breather here for a second. So further, if you, let's say, for example, you come to us, right, and your spouse has passed away, and you want to name co-trustees. You're saying, you know what, I still have, I'm still competent, I still have capacity, I'm still managing my affairs, but I want to name my my middle child who lives 10 miles away from me, who's very financially responsible. I want to name them as a co-trustee. Okay. This is also a time when we have to do documents to effectuate that, to make sure that your wishes and desires are appropriately reflected, and then giving those documents to the right financial institutions to make sure that that actually reflects. Just because we draft those documents doesn't mean that person's on title. Okay. So there are things that have to happen regarding the transfer of assets, whether it's upon a first spouse dying, whether it's upon a surviving spouse, whether it's a distant relative, whoever it is, right? There are transfer of assets, whether it's updating title, whether it's paying off debts, whether it's making final distributions, right? We have to abide by and follow the guidelines, whether it's through the probate court or whether it's through the trust. Okay, financial obligations. Okay, this is a very important aspect, and it can be very confusing. And there's differences between a probate administration, and there's differences between a trust administration, especially when it comes to account titles, especially when it comes to debts and creditors. Okay, there are some differing opinions when it comes to the law in these areas. So if you talk to one attorney or one law firm and you go to another law firm, they may have a little bit of slightly different opinion. Okay, so I'm going to say this from a very general standpoint. And then, you can contact us for your particular circumstances, and we can kind of delve into that a little bit further, right? But a lot of times, surviving spouse will come in, or the kids or beneficiaries, and say, okay, there are debts. How do we handle the debts? How do we handle the creditors, right? You have secured and unsecured and other types. I was actually talking just before this webinar started with a colleague of mine here at Copenhagen, and she was kind of asking about, her and her spouse have different credit cards. They have a credit card. She has one in her name. He has one in his name. And she thought that if, she passed away or he passed away, those were just debts that were just a part of their estate. And I, it was like, potentially the answer to that is Maybe. It depends. Okay. But I'll walk you through a scenario of where it wouldn't be. Okay. Let's say that they got married in 2000 and then each of them opened up their own credit card in 2005, right? And they were paying their own credit card bill with their own employment salaries, right? They weren't paying each other's, they were paying their own. So really on paper and based on the circumstances and scenario that I've given you, it sound like if one passed away, the other would not have to deal with that person's debt. And the answer would be no. Okay. They opened up these credit cards during their marriage, right? And if you live in California, it is a community property estate. Okay. Not only that, but your income that you make during your marriage is community property. So even if I, am earning my attorney salary here and I'm depositing my attorney salary into an account with my name alone on it, right? Just says Mark O'Brien checking account at Bank of America. And I'm paying my Mark O'Brien Bank of America credit card with those funds. I'm using community property funds to pay that debt. Okay. And not only that, that debt is also community property, even though the title only has my name on it. So when I pass away, is that creditor potentially entitled to come after my spouse for those funds? Yes, potentially. But this depends on whether there's a probate or a trust, right? How you respond to them will depend. If it's a probate estate, right? As a part of a probate under California law, we have to give notice to any known creditors and reasonably anticipated creditors. So if I know that my spouse has a credit card, I have to give notice to them and I have to give notice to Bank of America's credit card department, and they have to be given the opportunity to submit a creditor claim against the estate, right? And if I've opened up a probate, obviously there's probate assets. And if it's a viable and it is a true debt, I'm required to satisfy that debt. Now, I'm going to tell the client to contact me, and I'm going to walk them through. Hey, you could still try to negotiate, right? You can always try to negotiate. They may come back and you may be unfruitful, but at least we'll walk you through that process and what the pros and cons are and what your options are. But through the trust, right? You can kind of, and this is kind of where differing attorneys will have a different opinion, right? I would say if there's a credit card, regardless of whether or not it was a community property or separate property, doesn't matter to me, right? If there is no probate estate, that debt is technically a part of your spouse or your loved one's probate estate, okay? And there is, you could basically tell that creditor there is no estate, right? There is no probate estate. And you're legally not saying anything incorrect, okay? Because there is a trust estate, but there is no probate estate. Because a creditor under California law can also open up a probate for the sole purpose of pursuing a creditor claim, okay? So you can kind of go the extreme route and force them to go open up a probate estate, or you can contact them and say, you have a little bit more wiggle room to negotiate. And a lot of times you can get that debt paid for less, sometimes even pennies on the dollar. And then sometimes there are certain circumstances where the dollar amount is not worth fighting, right? If you're going to be in contact with us or you're going to be asking us to be handling this and we're billing hourly for it, it could be that we bill more in attorney's fees than the cost of the debt itself. So you and I would have a conversation about whether that's prudent for you to fight this, right? And if it's a valid debt, and you are trying to morally and ethically, right? Because there's also these concerns, right? And if you're religious from a God standpoint, you're trying to do things righteously, right? And you're trying to pay it off. It's a valid debt, then you pay it off, okay? As you can see, there's different circumstances, right? And there's different conversations that can be had, and you have different options depending on the type of debt, right? Whether it's secured, whether it's unsecured, and depending on what type of administration is going on. Is there a probate? Is there a trust? Is it a conservatorship? Is it an incapacity, but a private incapacity administration? Is it via a guardianship? Is it a minor's estate, right? There are so many different factors that change and manipulate this type. Was it a debt that was opened prior to the marriage, right? Was this a loan that your spouse obtained on an investment property that he or she purchased prior to the marriage that no funds from the marital estate have been paying, right? That's an important conversation to have with us, because in that instance, that debt would, even if it's secured, right, by that real property, would most likely not be, the surviving spouse would most likely not be responsible for that, right? Most of the time, right? It depends on if there was any commingling or transmutation, but we can have that conversation with you, okay? Along with that, managing joint accounts and titles, right? So if there are joint accounts, you need to be talking to your advisors, you need to be updating joint accounts. Sometimes we're going to tell you don't close a joint account, right? Because if you close all the joint accounts and you remove your surviving spouse or the deceased one from all accounts, you may not, there are some refunds that may come in from the date of death over the next 6 months, 12 months, 18 months, right? And you'll have nowhere to put it. So you'll have to deal with these companies to reissue the checks. Sometimes that can be annoying. So there's some things you'll want to talk to us about strategically wise on how to update title to accounts, how to maintain certain accounts, and then what's the best way to move forward and progress based on your particular scenario. Ongoing financial responsibilities, bills, taxes, right? Almost always you're going to have, if you know, there's utilities and property taxes. If you have not filed, or that person did not file their income tax for the last tax year, right? You're going to have to be filing that, or putting it on extension, or contacting the IRS to see what your options are. You're going to have to find out if there's any back paid or past due taxes that have not been paid, right? Making sure that those are taken care of. But that also depends on whether a trust or a probate has been opened, right? So we're going to need to have those conversations, because the avenue and the mechanism, the procedure that you have to do may be different, okay? Protecting trust assets. So this is what I kind of tell surviving spouses, and if it's a second spouse who's passed away and their kids or other beneficiaries, I say, look, when you do a trust administration, it is a suit. When you come in to meet with me or another trust administration attorney, it is a pseudo estate planning meeting as well, right? Because we are going to sit down and we're going to say, and always the surviving spouse, okay, this is all the things we have to do for this trust administration, but simultaneously, this is a great time to make sure that your affairs are in order and done appropriately, and that your assets have been funded into the trust, and that the trust is being administered appropriately, and that you're not doing anything to jeopardize that protection, or you're not doing anything to potentially cause a future probate or to cause a potential lawsuit between your family members and so on. Okay, so we have that discussion, and like I said, it's a pseudo estate planning meeting. It's a great time to also make sure, because you're gathering all this other information, you're doing all these other tasks. It's a great time to also make sure that your affairs are in order to protect the trust assets, because you have the most knowledge at this time. You're not going to have the most knowledge 10 years after that. You're going to have forgotten a lot of these things that you have gone through, and the reasons and purposes behind them. So it's a good time to do all this simultaneously. If you do not have the mental or emotional capacity to do it simultaneously, then at least in the near future, right? At least 6 months, a year, 18 months later, right? We're having these discussions. We're at least reviewing things to make sure that everything's done appropriately. And then addressing unforeseen expenses. That kind of goes in with the debts and creditors, checking the mail, getting access to the digital online presence, contacting CPA advisors, looking at the tax returns to see what was being reported, what accounts there are, checking the mail to see what invoices, contacting the taxing authorities to see what the outstanding taxes on, and this goes on and on and on. Understanding the deceased financial situation, right? Understanding if they did not give you a good idea of what their financial portfolio is, right? You're going to have to become quite familiar, right? Very intricately involved in what the financial situation was. What are the outstanding debts? What are the assets? What assets are income producing? What are the tax implications? How many advisors are there? Was this person managing their own financial investments? Did they have a professional speaking with them? Were they doing their own taxes? Were using an accountant or a CPA, right? Talking to all these people, understanding what the financial outlook looks like, because that's going to dictate what you have to do, right? Depending on what the assets are, where they are, how they're titled, how they're managed, will all change how you approach and handle those specific assets. Okay. Along with that, closing or transferring financial accounts, right? Again, when a loved one passes away, it is a great opportunity to consolidate, right? To make the estate more or easier, right? For ease of access, potentially ease of management, for efficiency, for profitability, right? Or because your circumstances and needs have changed. Maybe the financial outlook of your spouse was created 20 years ago and your needs are different. Maybe you're in hospice, maybe you're in assisted living facility, or maybe you have different income sources and you don't need these funds as much. Okay. Or you have, or interest rates have changed, inflation has changed, Congress has changed. The geopolitical scenarios have changed, right? All of these things can kind of factor in and change what you may or may not need. So closing some of the accounts, transferring them, doing things that are necessary for you or your loved ones is a great time to look at that. Okay. Communicating with creditors, right? Contacting them. I'm not going to go into that again because we kind of talked about the creditors based on what your creditors are, based on how that credit looks like, right? Whether it's secured, unsecured, the type of debt, when it was opened, how much is outstanding, whether it's a probate trust, right? We'll have to be discussing those and communicating with those creditors. Understanding estate taxes, right? Meet with your CPA, meet with the attorney. We're going to go through not just estate taxes, but any and all taxes that may be applicable to your surviving spouse or your loved one's estate, and then financial record keeping. Some people are meticulous. Some people are fantastic and they bring in a very nice, concise folder. Here's all the financial information. And I say, thank you very much. You just saved yourself and the estate thousands of dollars. Some people go, I tried to provide all the information that you asked for, but my loved one was a hoarder or was not particularly neat or maintained files very appropriately, or they kept documents for years and years and years, which made it convoluted, right? In that case, it's kind of out of your hand. But at that time, once you put all this time and effort in, you can kind of make sure from that point going forward that all the record keeping is done appropriately. It's concise. It's easy for someone outside of your own purview to understand it. Document maintenance, okay, and updating estate planning documents. These are things that I always talk to clients about. Anytime, based on the type of trust you have, right? There are different trust designs. Sometimes you can update excuse me. Sometimes if you're a surviving spouse, you have the ability to update the entire trust. Sometimes we have what's called an AB trust, and you can only update the survivor's portion. Sometimes we have an ABC trust, and you can only update the A and you cannot update the B and C. Sometimes your loved ones have a life insurance trust or a more complex estate planning tool, and we have to talk about whether or not they can be updated. And if they can or cannot, we still have to talk about how they are maintained, how they are administered, okay? Always be reviewing, at least reviewing, if not revising, reviewing your wills and trusts. Okay. Every 3 to 4 years, doesn't matter what life circumstance you're going through, every 3 to 4 years. And then on top of that, any major life occurrences or events. Okay. Marriage, divorce, birth of a child, birth of a grandchild. Your child turns 18, a child goes to college, you or a child is traveling domestically, you or a child or another beneficiary is traveling in foreign or internationally. Okay. Are there capacity issues? Did your child have a child with special needs? Is someone now receiving state or federal benefits, right? These are all conversations and times where you need to be reviewing your trust, and not just your trust, but your assets. I have instances where someone's created a special needs trust through their trust, right? It says my child, I have 3 kids and 2 of them are going to get their shares outright. And my third child is special needs. So it's going to go into a special needs trust. And that's fantastic. I properly fund my trust. Okay. Excuse me. And when I pass away, my trustee administers the trust and distributes the funds to my 2 kids outright, and then puts the funds in a special needs trust for my 3rd kid. That's fantastic. But I had an IRA that had $1 million, and my IRA says it goes to my biological kids. And when I pass away, right? So now all of a sudden, 1/3 of that IRA just went to my special needs child outright. And did that outright distribution just knock him or her off of receiving state and federal benefits? Yes, most likely, yes. Right. So we have to be thinking from a big picture. It's not just the trust, but we're reviewing your financial plan from a big picture perspective is very important. Ensuring compliance with current laws and regulation. Can't tell you how many times we have a trust that was done 30 years ago that has language in it that is completely outdated, but we are still required to abide by it or have to deal with it because it was outdated, right? Or the design was based off of the current legal climate back in 1998. So the design was done in a certain way to deal with the laws that are not applicable anymore. So that would change the design of that plan to make things, whether it's more efficient or more smooth or more cost effective. So it's very important to be reviewing these things to make sure that they're staying up to date with the current laws. And again, keeping beneficiary information up to date. That was exactly that point that I just used with that special needs trust, right? Making sure that could have been avoided if I looked at my entire financial plan and made sure that the special needs trust was the beneficiary of that IRA rather than my special needs beneficiary, him or herself. Okay. Also making sure that your beneficiary is up to date for your surviving spouse, right? Making sure that if you just rolled over your spouse's retirement plan into your name, that you're updating your beneficiaries to reflect either the trust or your kids or whoever you're trying to name, right? Making sure it's up to date. And then regularly scheduling reviews with legal advisors. I would suggest every 3 to 4 years that you schedule a review with your CPA. You'll use a CPA every year, but your financial advisor and your attorney at a minimum every 3 to 4 years. It could be that you meet with us or them and they say, hey, you've done a great job. Everything's up to date. Everything's current. No changes, right? That's worst case scenario. Best case scenario, we tell you, hey, a lot of things have changed. Your life has changed. This has changed. Your desires have changed. We need to change, make these changes and updates, and then we can kind of go from there. Okay. Um, Time to update the document maintenance continued, right? Storing documents securely, making sure you're not just keeping them out in the open. This is going to change based on your particular circumstance. I won't go too far into that. Handling digital assets, this is very important. There are online vaults that you can create, password vaults that you create for your loved ones. Otherwise, you're going to need to be telling your loved ones where this information is. So if you do not trust them, right? If you name this person, if you name me as your successor trustee, and then or so that's not using me. Let's say you name your child as successor trustee, and I say, do you have digital assets? And you say yes. And I say, okay, you should at least at a minimum be telling this individual where they can find the information to access. And you go, I don't want to give them this information. I don't trust them. My follow-up question to you would be, well, then why are you naming them successor trustee? If you trust them to manage your trust and affairs, but you don't trust them, right? That kind of conflicts. So we have to have that discussion, and we need to be more aware of that because more and more our assets are moving online, right? Whether it's our checking, savings accounts, whether it's investment accounts, whether it's crypto or other digital assets, right? We need to be having this discussion, updating powers of attorney and healthcare directives. Does your healthcare directive name the appropriate person? Maybe this person's moved out of state. Maybe this person has health issues themselves and can no longer act on your behalf. Maybe it's someone who you lost a relationship with, right? Maybe you're not close to this person anymore and you don't want them to be making these determinations for your health. 2, does it actually portray your wishes and desires, right? What you wanted in 1999 may not be what you want in 2024. You may have changed your mind. There may have been medical advances. There may have been certain things that have changed and swayed what your wishes are, right? Powers of attorney, same concept, right? Are the people appropriate? Are the powers we're giving appropriate? Is the document up to date? Is it effective? Unfortunately, I just met with a client yesterday. I had to explain to them that even though your power of attorney is effective, when you signed it, banks are hesitant to accept powers of attorney that are 5 years or older. That is not California law. Your power of attorney is still effective, but their legal department is blocking people from using those power of attorney. Right. And that's something, if you were meeting with your attorney every 3 to 4 years, you could have a discussion about that. Hey, my power of attorney is 6 years old. Do we need to update it? Right. Well, most likely not. 6 years is pretty close to 5. But if you're at 7, 8, 9, that may be a good time to say, hey, we should probably update this document just at a minimum so that it has a signature and notary date of 2024 rather than 2016. Okay. Addressing changes in personal circumstances, right? Kind of goes along the line of what are your personal financial circumstances? Have they changed? Have your needs from a financial standpoint changed? Have your family makeup changed? Are there grandkids, kids, great grandkids? Have there been divorces? Have there been marriages? Have there been some issues, right? And intra or inter-family fighting, right? Have you lost relationships with certain people? Have you gained relationships with certain people? Do you want to leave? Are you more charitably inclined now than you were 20 years ago? Okay. So we have to have all those conversations, and that's what document maintenance entails. It also entails reviewing and updating your documents. Okay. And then documenting all changes and the reviews accordingly. I always suggest, please do not write on the trust documents. Please do not make these changes yourself. That a lot of times creates more confusion, and really a lot of times you created a scenario where you have, potentially forced your loved ones into litigation, right? And because there are a whole host of ways. What happens if you cross through? You said, I want to leave $50,000 to this grandchild, and you put a line through it and you initialed it. Okay. Who's to say that was you? Right? How do we know that was you 20 years later? Yes, you initialed it, but could I forge your initial? Sure. Yes, I can. Does it happen? Yes, unfortunately. Who's to say that if I was that grandchild, I would file, let's say it was a $500,000 gift and you cross through it, right? You do it a normal X. Who's to say I can't file a lawsuit and say to the court, actually, Your Honor, if we take a microscopic, a forensic approach to this person technically only crossed out certain letters within each word as I went through. So technically, I can make an argument that your intent was just to get rid of each letter within through each word that you crossed through, right? Is that a viable legal argument? Unfortunately, it is, right? Or if you cross out a left slash rather than a right slash, what does that mean, right? What was your intent, right? And if you're passed away and you cannot speak for yourself, there's a whole host of different viewpoints that we can take to make this argument. So make sure that you're meeting with your advisors and doing things appropriately to negate fighting and lawsuits later on. Okay, that is the conclusion. So there's a couple of things we'll kind of wrap up here before we take off, and before I kind of answer some questions, right? How can we help? Consider what matters most to you, right? Sometimes people, let's say you have a $30 million estate and you would be subject to federal estate tax, right? Inheritance tax, death tax. Some people don't really care about that, right? Because they're like, hey, that's my loved ones that have to deal with that. I don't want to plan for that. Some people are like, hey, I don't want any money going to the government. I don't care if I'm here or not here. Let's plan for that. Okay. Some people care about incapacity. Some people care about charitable giving. Some people really care about who has access to their assets, who's getting this information, right? It just depends on your particular circumstances, your desires, your wishes, and so on. Okay. Determining responsible successors and representatives, right? We're having the discussion. If you have 3 children, and a lot of times people will say, well, I'm just going to automatically name my oldest child because they're my oldest child. Maybe that person is not the appropriate. Maybe none of the children are appropriate, right? Maybe a friend, maybe an advisor, maybe somebody else is the appropriate person to be managing your affairs. And maybe that changes. Maybe your oldest child is 28 and not the appropriate person, and your 2 other children are 18 and 20, and they're just too young, right? So maybe you name someone else, and then 20 years later, you go, oh, wow, all 3 of these people my kids are doing great, and they're financially literate, and they're responsible, right? So I can now name them and change those advisors, and I no longer am even friends with this person. So I want to remove them, okay? And then provide a plan before it is needed. Yesterday was too late. I always say that in almost every webinar I do. Yesterday was too late. So getting on top of this while you're competent, while you have capacity, while you have knowledge, while you have good relationships, right? These are all positive benefits to doing things now versus later. Not to mention the cost, okay? All of these things have costs, right? That is unavoidable. But doing things when it is easier will help keep those costs down rather than emergency situations or whether there's contested situations, right? That all creates a greater attorney's fees and costs and CPA taxes and penalties and so on. Okay, we can give you the tools to take care of your planning, whether that's estate planning, estate administration, kind of like I just discuss and plan these things while you are alive and well, while everyone's, and I've heard a couple of the other attorneys here say, while you are alive, you are the referee, right? You're refereeing your estate, and the family members are playing along well. But once you are gone, whether it's a surviving spouse or whether it's children or other heirs and family members, right? Things change. Money changes people. I hate to say that, but it happens. So just making sure that you're planning for these things appropriately, prudently, timely, all helps. And it all helps your loved ones grieve easier, right? When I say grieve easier, I mean allows them to actually take time to grieve rather than having to deal with all of these issues. And then like I've always said numerous times here, review, update, and maintain your estate plan. Okay, some facts about our firm, right? When we opened, how many attorneys we have, the amount of experience, certain tax degrees. We have certified specialists, highly qualified support staff, numerous offices, and so on. Kind of go there. Here's our contact page. You can call us, visit on our website, email us. Please select this digital evaluation. If there's anything that we can do, of course, I want a positive review for myself and my speaking and the knowledge I'm giving you. But if there's any type of criticism that's going to help us portray information better, give you the tools that you need, please let us know. I will not take it personally. I want to improve my speaking. I want to improve this process. I want to improve the webinar. I want to improve the meetings I have with clients, whether it's a state administration or estate planning, whatever it is, however it is. Your input is invaluable, and it can help me. And by helping me, I can help you. So that's something I'm going to keep just harp on. Please fill it out. Please let us know what we can do better. What we are doing, also within that, please let us know what we are doing well, so that we can continue to do that. So we don't make sure that we don't, take that away from some of the speaking engagements that we have. Okay, I'm going to keep it on this page for a while. Let's just see what time it is here. 11:30. Okay, it's getting. I'll try to briefly run through some questions here on the Q&A. Okay. Okay, looks like there's a couple of them that I might be able to answer. So Vincent asks, are you able to process a trust will that has been drawn up by another attorney? Absolutely. It does not matter who draws up the documents. All that I suggest is you make sure that if someone has passed away and they have a trust, make sure you go to an attorney who specializes in trust administrations, okay? Sometimes they'll go to an estate planning attorney and they only do estate planning. They don't do trust administration. So just make sure you're asking the appropriate probing questions. But yes, you can go to any attorney as long as they're within the state of California and the trust says that it's under California law. If someone has created a trust for another law in another state, or it says this is under the jurisdiction of Oregon or Oregon laws, right? Don't come to a California attorney to do that, okay? Or if a California says they will do it, have some hesitation, okay? Okay, anonymous attendee asked, if my mother has a trust and she and I have a joint savings account, would this go to probate? I haven't transferred these funds because this account collects more interest on the account than the trust checking account. Great question. And it's very common. I have a joint account with my mother and father as well. So joint accounts avoid probate. So in this particular instance, if your mother passes away, right, she has a trust, but she also has a joint savings account with you. So the trust assets would go via the trust, and that joint account with you would just be transferred to you. So now it's your asset. Okay. So yes, that would avoid probate. Yes, so that would, like I said, that would avoid probate, but there are other issues with that, right? One of those issues being, if this was truly not your account and she just added you for ease of access, right? By operational law, let's say there's 30,000 in there, it became yours. But your siblings may say, hey, what the heck? This should have been a trust asset. Why are you now doing this? And if your name is such trustee, did you potentially just breach your duties as trustee, right? So there's other conversations here that need to have. But to answer your question, at least briefly, yes, it would avoid probate. Okay, some other questions here. Do you have to provide a copy of the trust to the beneficiaries when the first spouse dies? Or does that depend on the type of trust that was created? Or is it only required when both spouses die? Great question. And the answer is it depends on the type of trust created. There are certain trusts that where everything goes to the surviving spouse, that no notice has to be given to anybody. Because if the trust says my spouse can amend and revoke the entire trust, right, then we're not going to give it to anybody because she or he can change the beneficiaries at their will. Okay. So it depends on the type of trust. And that is something that's very important, especially when you come in when someone's passed away. You'll learn, oh, I need to give notices or I don't need to give notices to based on the type of trust. Okay. Along with that, it was, do you have to provide a copy of the trust to beneficiary? Oh, sorry, that's a repeat of that question. Okay. Do you recommend having a joint bank account with the successor trustee with 15 to 25,000 to pay for funeral expenses or any other necessary expenses, such as hiring your firm? I've heard it takes some time for the successor trustee to access trust bank accounts. Yes, it does take a little bit of time. It's not nearly as daunting as a probate, but there can be some time before you access those trust assets. Okay, it may take a couple of weeks. It may take, could take 2 to 3 weeks, could take 4 to 6 weeks, and you are left with that interim period without funds. Generally speaking, I would say don't have a joint bank account because of the question I just answered before, right? There are other issues that come up, but is it a strategy to allow an interim period? Yes. Are there pros and cons to it? Yes. So you have to take that into consideration if you're going to be doing that. I generally suggest not doing that. But have I seen it? Does it happen? Yes. Okay. Here's a here's a quite a question. Is there a dollar limit on what can go into a pour over will? So as I said, if you have a will, say a pour over will is a very specific type of will. So the answer to your question is it would be irrelevant with the dollar amount. A pour over will is done with a trust. And what the pour over will says is if so I'll talk about myself. I have a trust and I have a pour over will. I created the trust in 2006 and I funded my house. I funded all of my assets into my trust. Okay. I did what I was supposed to do. In 2022, I opened up a Fidelity investment account, right? And I put $300,000 in that investment account and I put it in my name. I forgot to put it in my trust. And then I die, and then I pass away in 2024. Okay. My heir, whoever I named in my will, that $300,000 Fidelity account is a probate asset, right? But my executor is going to put my will into probate, and what my will says is, it says everything in my probate estate goes to my trust, right? It pours over from my probate estate into my trust. So it is a safety net. It is a catch-all for when I forget to title things in my trust. So that ultimately at the end of the probate, it doesn't go to individuals, it goes to the trustee of my trust to be administered per the terms of the trust. Okay. Okay. So I think that's all the time that we have for now. Again, thank you so much for joining us today. Feel free to contact us to schedule an appointment, whether it's with the estate planning attorneys or an administration attorney. Feel free to fill out the digital evaluation and let us know how we did. Okay. Thank you once again for spending your time with us. It was a pleasure. I hope I gave you some information that was useful. Hopefully I didn't overwhelm you too much, although I feel like I have. That's never my aim, but I like to just give as much information as I can to make our clients and the general public as informed as possible so that they can plan appropriately. Okay. Otherwise, have a great rest of your day, great rest of your week, and God bless.